SJC-11732, Commonwealth versus Ashley Fernandez.
Good morning, Your Honors. May it please the Court, Leslie O'Brien for Mr. Fernandez. Mr. Fernandez's first argument concerns the wrongful denial of his motion to suppress photographs that were seized from his digital camera. The photographs were seized pursuant to a warrant, but a warrant that was issued without a showing of probable cause that the camera to be searched had any relationship whatever to the crime that was under investigation. The first warrant, in the first warrant, the application actually made no effort to draw such a connection or to give the magistrate any reason to believe that there was such a connection.
Are you suggesting that there'd have to be some kind of evidence that the defendant likely took pictures of the crime?
There has to be, well, the way this court has phrased it, there has to be specific information that there would be evidence related to the crime found in that particular item.
But that was a case involving a cell phone, correct?
Well, there were the cases involving the cell phone, yes, but this is certainly a related matter. A cell phone can be a camera, and there are cases where a cell phone's camera, the search of a cell phone's camera has been discussed, and it's clear that the search of a camera without cause to look at the pictures in the cell phone would be improper without a showing.
Isn't a camera different from a cell? I mean, a cell phone, as we've said, basically contains your whole life. Camera's different, isn't it?
A camera's different, but obviously a camera, like a cell phone, can contain extremely personal information. And as I say, the court has determined that in regard to a cell phone, you might have, the police might have reason to look at call logs and the like, but not have reason to look at the photographs in a cell phone. So it's the same type of situation. If the police haven't given specific information why the photographs in the cell phone
What kind of specific information would they have? I mean, it sounds like the camera would always be off limits unless the defendant is seen taking pictures at the crime scene, right? I mean, so I guess you can never get to a camera?
I wouldn't say you could never get to the camera. I know that the police or that the court reasoned in the Dorilas case that there was evidence of threats, and that the threats were made by way of the phone call, by way of the cell phone, by way of a cell phone, and that therefore, since threats could be made by way of photographs, that was.
So what did the motion
there was a
judge-
dissent to that was that I thought was rather compelling. But in any case, that was the decision of the court. But the court held that there was specific information that allowed the photographs to be
What did the motion judge conclude?
I'm sorry, Your Honor.
What did the motion judge say when the motion to suppress was raised on this point? What was his reasoning as to why it was denied? What did he say?
His reasoning was accepted. He accepted the reasoning of the second warrant. And I did want to point out that by the time of the second warrant, the search had already taken place pursuant to this first warrant that gave no reason for probable cause. But
do you mean the search of the photos on the phone, or just seizure of the phone?
I think I was saying phone.
The search of the camera.
The search of the camera. The camera was seized at the scene, but the police had already looked at the photographs. They powered it on, they opened it up, they looked at the photographs. Then they apparently realized, oh, this looks like a mistake. We're going to seize the camera. We're going to go back. We're going to get a second warrant. Now, there's no argument made at any time that getting that second warrant removed the taint of that first clearly illegal search of opening up the phone.
Let's assume that's true. Let's just assume for the sake of argument, you're absolutely 100% correct, and that evidence should have been suppressed. What difference does that make in this case where there's so much other evidence?
Because the pictures themselves, Your Honor, frankly horrifying. And as a matter of fact, the prosecutor herself, and this is volume 5, I believe it's volume 5, page 45, admitted freely that these photographs were potentially prejudicial, even though she was arguing that they were more probative than prejudicial. And when we say something is prejudicial, obviously we mean that they are likely
Unfair
to create...
prejudice is what you're looking for,
Yes,
not just prejudice, right?
Unfair prejudice. That's exactly the point here, that they created an unfair prejudice, that they would create a bias against the defendant that would, and in this case, ruin any possibility that he might have of having a verdict that was less than first-degree murder. And that was the effect. And as I say, the prosecutor freely acknowledged that there was a potential for prejudice here.
Is it not fair to say, though, that the photographs went to extreme atrocity or cruelty as opposed to premeditation?
Well, it went to both. And now the prosecutor's argument in the brief is that there's no reason to think there was any seepage. But as I've said, of course there's seepage when we're talking about unfair prejudice. We're talking about creating a bias against the defendant. So it would bias the jurors on both theories.
Were there
But
autopsy pictures also introduced? Because I mean, this is a grisly murder scene anyway.
Yes.
So did they take pictures? Did the police take pictures of the body, and were those introduced at trial?
I know I recall that there were photographs of the body, or the wrapped body. I recall those photographs. I don't specifically recall whether autopsy photographs.
So we have to measure the difference in the impact on the jury between the photos that were legitimately in and the photos that may not have been legitimately been in, right?
Well, no, Your Honor, because there was no argument raised. Assuming that there were such photographs raised, there was no argument that those were unlawfully seized. We're talking about the violation of the defendant's Fourth Amendment.
No, but you're saying that this is unfairly prejudicial even on the premeditated murder conviction.
Yes.
But if there also were autopsy, and I haven't looked at the whole record, but if there are also autopsy pictures showing the victim, we're really comparing the pictures he had with his hands on her neck with the pictures that would otherwise be introduced at trial, right? And the prejudice that's caused by the difference.
I would suggest that there's an enormous difference, Your Honor, and that any reasonable person looking at those photographs would see an enormous difference as far as the potential prejudice to the defendant.
Did the defendant claim that there was any reasonable provocation? Was there any voluntary manslaughter instruction given here?
There was a voluntary manslaughter instruction given, Your Honor. And
Based on what evidence?
it was based on the evidence that the testimony of the defendant was that the deceased was pushing him around, spitting in his face, that they grabbed each other, that they fell to the floor. The prosecutor agreed that the voluntary instruction, that it was a close case, but that was warranted. Even if it wasn't warranted, this whole argument that the photograph showed the defendant's cold-bloodedness and that he was enjoying the murder, enjoying killing the victim, also had an impact on his testimony that he was in a sudden rage. If the jurors believed that he was in a sudden, uncontrollable rage, then they may not have found premeditation. There's a large difference between first and second-degree murder. So clearly, the photographs, in addition to the unfair prejudice against the defendant, because of the way it was argued, those photographs had also a direct relationship to the issue, to the jury's issue to decide between premeditated murder and second-degree murder.
The judge on the motion to suppress talks about we've got a domestic relationship here and a killing in a domestic relationship, and the camera is going to document that relationship in some ways. Isn't that, there's some sense to that, isn't there?
Well, For one thing, it goes beyond, we're talking about the four corners of the affidavit. None of the affidavits came up with any such theory. And I'd suggest that theory
One of the
with all.
police officers, didn't the affidavit reference, the police officers reference, talking about his experience with how electronic devices are used and killers sometimes document their killings?
Well, Your Honor, I'd suggest even if that happens in 1 in 1,000 cases, and I think even that would be a stretch, even if that happens in 1 in 1,000 cases, that's not probable cause. Probable cause deals with probability. There was no probability, and that was the rationale in the second warrant. Again, I suggest there was nothing to remove the initial taint from that unlawful search of the camera at the apartment.
So I just want to make sure I understand that. So there's clearly probable cause for the search warrant itself, right? There's no doubt about that, given his confession and everything else. So we need probable cause for each individual item seized?
Well, there needs to be probable cause.
I should know the answer to that, but it's a question. So,
Well, yes, I think that in particular the cases that have dealt with cell phones, such as White and Dorolas and Pierce, all make that perfectly clear. That there has to be a specific reason to look in someone's.
But you have probable cause to search the place, and obviously then there's things that come, like obviously if you find the murder weapon, you don't need to have listed it in there. You've got plain view observations once you're inside. So when you see a camera in a murder scene, are you able to pick? I mean, it seems like you should be able to pick that up, right? I mean, it's.
Well, I'd suggest it's no different than if the police were at a murder scene and they found cell phones there. It would depend on whether they had established that there were specific reasons to believe that the cell phones contained evidence of the crime.
Well, what if
That's
they
been
found a
made very
photo
clear by this
scrapbook?
court.
What if it was a photograph scrapbook, like a scrapbook or a photograph book? Would that have been okay to take?
If the scrapbook could have contained, there's actually a case, and I can't think of the name, where the court held that a scrapbook or an album could have been opened because it could have contained a knife or it could have contained something in relation to the crime. Here you have a camera. The camera can't contain anything other than photographs, and the police did not have probable cause to believe that there was anything in that camera related to the crime.
This is a digital camera, right? Digital camera not only records photographs, but records the timing of photographs.
Yes.
So we're going to get a sense. We could find what she looked like before this incident. There might be a picture of her 2 days earlier without any of this bruising. It just, I don't know.
There could be anything in there, Your Honor.
Well,
there
but
could be anything at all in there.
Yeah,
But
but
we're
what-
talking about probable cause, and that's
No,
not
no,
probable
I think
cause.
you're confusing. There's probable cause for the warrant.
Yes.
Once we get into the apartment, I'm not sure you're right that we have probable cause for the camera itself. I'm not sure that's exactly right, but you may be right. But it strikes me as you're narrowing what the police are allowed to collect once they have probable cause to enter into an apartment.
Well, I'd ask you to consider the other possibility that the police come into the apartment, they're likely to see a computer, they might even see a cell phone. If they haven't established probable cause to search those things, they're not authorized to search those things.
But are they
This
authorized to seize them and wait for another warrant?
They could secure them.
Well, okay.
They
And
may
what if
have
it
to
was,
seize them
one
to
of those,
secure them.
like a device, like an Alexa or something like that would possibly have other information?
They might have reason enough to secure those items and obtain a warrant if they could establish probable cause that there might be a connection between the Alexa and the crime that was committed.
But you're not willing to say that at this point, these devices are so much a part of our life that we can draw a common sense inference or take judicial notice of this?
No, because the court has plainly rejected
Well, we
that
did that
rationale.
in one or two cases regarding specific things like a cell phone record, but just in general, the general devices that record our everyday activities as we're going along, not even noticing.
Yes, the court has clearly rejected that rationale and required more. So I'm relying on the court's jurisprudence in that regard.
Just to be clear, there was an April 6 affidavit to search the residence.
There was, yes.
They
there was a warrant.
seized the digital camera at that time.
After searching it, yes.
Okay, so now, then they went back and got a second warrant on April 7th
Yes,
and specifically asked for permission to enter the digital camera.
they did.
Okay, so now, if they had in fact, I don't see anything in the April 7th affidavit which makes reference to what they saw in the camera.
No, they left that
April
out.
6th.
They left that out completely. They left
Okay.
out the fact that they had already searched the
Now, where
camera.
did we get the
They
evidence
knew
that they did that? Is that from a motion to suppress testimony?
did what?
or
I'm sorry,
That they
Your Honor.
searched the camera before they got the warrant?
That they yes.
Said they searched the camera, that they didn't put in the
They
second
did. There was testimony
affidavit?
about that. What I'm trying to remember exactly where that testimony was. But yes, there was testimony. They had already searched. That Detective Crump picked up the camera, powered it on, and hit the playback 5 different times to see the photographs that were seen.
But
So-
isn't it appropriate police work? It may not be appropriate police work for them to have looked at it on April 6th without getting a separate warrant, but it was appropriate police work, having done that, to not include that in the new affidavit, because if they had, you would say that the new affidavit was tainted by what you would claim was the illegal search on day one.
Well, my main argument is that getting the second warrant did nothing to remove the initial illegality of the search.
Okay, well,
The search
well,
was
but I mean,
illegal.
is that right? I don't know that that's right. I
The
mean,
search was
if they do get
illegal.
if they do get a search warrant and they don't use any information obtained improperly, and the judge, I think your better argument is that there was not probable cause to enter on April 7th to seek the digital phone, but or the digital camera, but it doesn't seem that there was any consequence to them looking at it if they indeed could independently obtain approval from a court to then do a search which would essentially cleanse the earlier.
It was still an anemic attempt at showing probable cause to
Well,
search that
I understand that.
camera.
That's a separate argument as to whether or
Hoping the
not.
court will not accept such an attempt.
And now I'm looking at that affidavit on page 116 of the appendix. And they are focused in part on the nature of the relationship, that it arguably would shed light on the nature of the relationship between the defendant and the victim. Is that something which is appropriate in terms of what a digital camera likely would reveal?
Well, again, it was not in the 4 corners of the affidavit. I'd suggest that it would be extraordinarily unusual for a camera to be expected to contain something like this camera contained, and there was no probable cause to believe that it did. I'm a little bit concerned about not reaching the
I'd like
Article
to-
36.
Yeah, I'd like you to address that. So,
Yes.
and when as you address it, I'd like you to talk about the last sentence and what the consulate wrote. But go ahead, address Article 36, your argument, and then we can probe.
Well, Your Honor, as the Commonwealth correctly suggests, the focus of this issue has to be on the August 7, 2012 hearing. It was at that hearing that Mr. Fernandes implored the court to assist him in reaching his consulate. He asked, "May I request to speak to a diplomatic representative?" He also handed up to the judge a letter that was marked and is in the supplemental appendix, where he specifically cited Article 36 of the Vienna Convention. And it was at that same hearing that defense counsel said, I cannot zealously represent this man who was facing.
Okay, but let's separate them out for a second. So what does Article 36 require? It requires assistance in notifying the consulate that you're in jail, right? Is that what it does? I'm trying to make sure I understand.
It requires that, it requires that the consulate be notified. It requires that the defendant be promptly notified of his right to have the consulate notified.
Okay,
and-
but bear with me. So this defendant knows about, he knows about his rights, it looks like, and he's notified them himself. The Commonwealth argues that's the purpose of the Article 36. Is that not right, or why isn't it right?
Well, it's not right. The Commonwealth shouldn't be permitted to sidestep its obligation, the clear obligation under Article 36 to notify the consulate.
I agree that they've not done what when he asked for that, someone should have done it, but he's done it himself. So I'm trying to understand, is that no harm, no foul, given that he's done it himself?
But there was no evidence and no reason to believe that the consulate, that the defendant was certainly making every effort to reach the consulate. There was no evidence that he reached the consulate. It was certainly to be expected that the consulate would be more likely to respond to some official type of notification. They responded when appellate counsel finally reached out and tried to reach the consulate. The consulate did respond, and the consulate said, what I was trying to get to was that as of that date, when trial counsel said, I cannot represent this man zealously at his trial for first-degree murder, the consulate said they would have provided him with counsel at that point.
Yeah, but then they're cute. The last sentence says, yes, we'd get you counsel, but guess what? Even though you have counsel, we don't have to pay for it. That's what the last sentence says.
That's not exactly what they said, and that's not the way Judge Feely assumed that the consulate was willing to pay for and provide.
He says that? He makes a finding to that effect?
He made a finding, yes.
What is it? Again, it's always nice to know what he actually did. What did he do? Did he found that they would have provided paid counsel for him?
He did. He may have said something along the lines of, I assume that counsel would have been provided by the consulate.
Or does he say, I assume they would have assisted in finding counsel or something like that?
Yes.
There's a big difference when
Well,
he
not finding
can't,
counsel.
but I mean, your argument is that he would have had another lawyer.
Yes, he should have had another lawyer, Your Honor, even if he was indigent, and even if the court had to pay for it and give him a continuance.
Well, hold on,
It's
but
stunning.
that's a separate issue. The judge decides that's a whole different issue than the consulate issue. Whether Judge Liu is correct or not, your argument is that the counsel, your other argument is that the counsel would have, the Indian consulate would have provided him a paid counsel. I don't get there based on this record, but I may be missing something.
Yes.
It's a whole other issue of whether Judge Liu should have allowed her to withdraw at that point. That's a different issue.
Well,
They may be somewhat connected, but you got to keep the different facts.
they are connected, Your Honor. And I'd suggest that the consul's letter is clear enough that they would have provided counsel. That the last sentence indicated that there wouldn't be any further liability on the part of the consulate, but the consulate said they would provide counsel. I'd like to, I realize I'm over time, if I could just draw the court's attention to a sentence from Commonwealth versus Gautreaux, which this court decided a year and a half before that hearing that I'm stressing. The court said that the principal type of assistance envisioned by Article 6 is the assistance of counsel. That's how this court, this is on page 752 of Gautreaux. The principal type of assistance envisioned by Article 36 was provided to Gautreaux since he was provided with the assistance of counsel. That's how this court has interpreted Article 36. The defendant should never have been forced to go to trial on a first-degree murder case with a lawyer who said she could not zealously represent him. I could not find any comparable case to that. and I'd ask the court to grant him a new trial.
Okay, thank you.
Thank you, Your Honors.
Mr. Steinfeld.
Morning. May it please the court, Kenneth Steinfeld for the Commonwealth. I'd like to focus the court's attention on the prosecutor's closing argument and the defendant's closing argument when determining whether there was, it was harmless beyond a reasonable doubt, if the admission of the photographs was harmful. Was error, whether it was harmless beyond a reasonable doubt as to the first-degree murder by deliberate premeditation. The prosecutor started her closing by saying there are two theories before you. There's deliberate premeditation and there's extreme atrocity or cruelty. First, I'm going to tell you all of the evidence that I believe supports the theory of deliberate premeditation. And she went through all of the things that I've cited in my brief. Then she came to extreme atrocity or cruelty. And she said, here are the factors, and now is when we get to the photographs. And her closing was exclusively limited, her discussion of the photographs was exclusively limited to the extreme atrocity or cruelty theory. Therefore, that's what the jury had in front of it. This court has said frequently, well, what did the prosecutor say in closing? And in the Hensley case, which I cite, this court even says you look to what was said in closing when determining what issues were before the jury. And I think it's very plain that in this case, everyone agreed that the photographs went to extreme atrocity or cruelty and not to deliberate premeditation.
Were there also autopsy photos of the victim?
Yes, there were, I think, a small number, and it was not a big issue in this case as it is in many. There's not a big fight about it, but there were, I think, of few, and I think you're right. The court, the jury would have had them in front of them as well. So that's got to be taken into account when determining whether or not they might have been inflamed so much by the photographs taken by the defendant that would have seeped over into their analysis of the deliberate premeditation claim.
Well, I mean, I've not looked at those photographs, but I gather, in contrast to the autopsy photographs, they they show him grabbing her neck.
Yes, they do, with his right hand.
So he's basically photographing with his left and
Yes.
grabbing her neck with his right.
Yes, that's correct. And he has his left, it is basically wrapped around her neck with 4 fingers on one side and his thumb on the other.
It's power.
They're graphic photographs, but they are.
It's power. It's not so much graphic, nor is it particularly prejudicial. It's just powerful.
Right, and powerful as to extreme atrocity or cruelty, not powerful as to...
How can you be so sure of that?
Well,
I mean, I understand you're saying that that's what the Commonwealth
Right, the
focused on
structure
in the
of the
closing,
argument.
but, I mean, the jury had them to use however they chose to use them.
Right, but they also had very, very strong, if not overwhelming, evidence of deliberate premeditation other than those photographs. It's not just that they weren't used that way in closing, but all of the stuff that the prosecutor focused on when talking about deliberate premeditation, the repeated statements that he was going to kill her, the calendar, all of these things, that's what the case was about. And I think that it's unlikely that the jury would have used the photographs when discussing that issue.
Really? Really? I mean, don't you think the fact that he had time to take the photograph of the victim he happened to be suffocating at the time, squeezing her neck, doesn't that indicate the ability to just sort of premeditate?
Well, but the evidence was that was about a half hour later. He wrote on the calendar 5 p.m. that he had killed her, and the date
Saying the
stamp.
photographs weren't really when he was killing her. He wasn't taking them when he was killing her.
Pardon me?
You don't think the photographs show when he was killing her?
No, I think that it's unsure, but I think the
Well,
better.
don't the photographs show a series sort of where like she is looking one way at one point and looks another way another point? I mean, it suggests
It
was
happening-
alive.
Yeah, that's right.
They appear to be post-mortem, based both on the timing of when the defendant says he killed her and when they were taken. If you look at the photographs, I'd be happy to get them before the court.
Does the camera indicate Is it after 5, or is it?
Yeah, 5:29, 5:29, 5:31, and then I think 5:34 and 5:36. So there are 5 pictures taken between 5:29 and 5:36. And I think that if you look at the pictures, you'll see that the position of the face and the eyes does not indicate that she's alive at the time. It's just he has moved her body by pushing down on it, and that explains why her eyes or her face go a certain way.
And he's written on a calendar, 5 p.m., something, the end of love or something? I can't remember what he's written.
End of love, finish. I'm sorry, end of story, no more love, 5 p.m., finish. And then he crosses out at some point, we're not exactly sure when, but then he crosses out the date of his trial on the 11th, which he never does. He claims he talks all about his OCD, and then he only makes a mark in a day after it happens, but he goes ahead and he marks that off, which is very strong evidence that he part of the reason that he killed her was to prevent her from testifying against him at that hearing.
Can we shift to the merits on the motion to suppress for a second? So
Certainly.
So there's no doubt there's probable cause to search the house, right?
Yes.
What does the affidavit say does it say anything about the relationship? I mean,
Absolutely. It says before the first search, the factual basis of both affidavits is the same, except for the addition of the officer's experience into the second. The first affidavit, before they've even found the camera, talks about they know that it's a domestic, that there's an outstanding case against the defendant for perpetrating violence against this defendant, and that the murder occurred in their apartment. That's all in the first affidavit, before they even find the camera in the first place. And so they definitely had, and in that first affidavit, they sought permission explicitly to seize a camera or devices. That was one of the devices that they.
So in the first affidavit, in the first affidavit, in the things they're looking to search, they say including a camera.
Yes, they do. Yes, they do.
And that's sort of oddly specific, or maybe
Well,
not.
I think it's based on their experience. I think it's specific but not odd. I think it's part of law enforcement officers' experience and knowing what they knew about the facts and circumstances of the case. And I'm not sure how far it gets me, but there was some odd behavior by the defendant.
Right.
And so that could show, well, he might be a kind of guy who would do something with a camera. That's not the best argument in the world, but it's part of what goes into
So they've also
determination.
So they at this time they know from the guy in the bar, right, that he says his girlfriend's dead in the apartment.
Right.
And is it so he's talking about it. He says he's going to be on TV. Is it a fair inference that the camera, that the guy may be documenting this thing because he thinks he's going to be famous? I don't know. I mean.
Well, I think that is part of the calculus. If he says in 15 days you're going to be reading about me, which suggests that there's something noteworthy or newsworthy. And of course, that doesn't specifically mean, yeah, I took photographs of it either during or afterwards. Of course, it doesn't say that as has been said earlier. It's going to be a rare case in which someone says, yeah, I took photographs, or someone says, yeah, I saw the person taking photographs. But I think if you add all those together and the officer's experiences, I think that that's enough to get them. I think they did it the right way, that Justice Gantz is right, that they were right not to include in the second affidavit.
But there's no problem with the seizure of the camera. The April 6th, they got plenty of probable cause. The seizure,
I agree with that, Your Honor.
The seizure of the camera is fine. It's the April 7th issue when they are seeking to search the camera that you get into the Durellis.
Yes, absolutely. That is where the rubber
It's the road.
hits the road in this case.
And I guess part of the problem I have is they've already seen what's inside of the camera on April 6th. So, and I understand that it would be appropriate for them not to taint the April 7th affidavit by including anything about that. But you have this strange comment that, it's not what's a double negative? I forget precisely. It's not unusual for somebody. Now, he's already, of course, seen that this is what this guy did.
Yes, that's certainly true. But again, the word strange.
I know that it is not unusual for individuals involved in homicides to memorialize their victim's death through video for later viewing, for guilt relief, or for enjoyment as trophies. Now, in 20 years, I've never seen that happening, but I don't claim to be a
Right.
state trooper, but I've
Right, and
been
these are
around.
5 who
But
have
of course, he's
160
already looked
I
inside
have,
and
by the, in my 20 years doing this, I've seen it a number of times where they've taken pictures of their crimes, yes.
And some of that now is different because we've got digital cameras and don't have to develop film.
Right, that's an even better reason to think why somebody would be able to keep it private. It's not connected to anything. Back to Justice Gantz's
But
point.
part of the problem is he's already seen what's in there,
Right.
so
Right,
we
but-
have it is not unusual, usually falls short of probable cause to believe that there's a substantial reason to believe there's going to be evidence of a crime in there.
But there is no argument, there was no request for a Franks hearing. There's no argument that the officer presented anything false or misleading in that affidavit.
I agree. It's not whether it's false or misleading, it's whether it's
So, but
whether
if it's true,
sufficient.
if it's true, which the magistrate was permitted to believe it, there's no allegation that it's false. If it's true, then it goes a long way towards providing probable cause. If you discount it entirely, you are in effect saying that these officers are being misleading or at worst perjuring themselves. But there's never any.
No. I mean, I'm not saying that. But, I mean, the problem is, we have Durellis, okay? So, I mean, if you were to say it's not unusual, which basically says you need some specific information to get into a cell phone.
Right, and I hear.
If we think it's enough to say it's not unusual to find that there may be telephone calls and say, well, that's enough, then Durellis is gone.
Well, but that's sort of like consciousness of guilt evidence. It's not enough standing alone. You have with it here not just the officer's experience, but the other circumstances of the nature of the crime.
We have a domestic relations dispute. We
Oh,
have
I
a
agree that it's a.
And that's different from Durellis. Durellis wasn't a domestic relations case. It was a crime scene. Somebody's doing someone's engaged in criminal activity, has nothing to do with domestic relations, and also we've got a defendant saying he's got a dead girlfriend in his apartment. That's got to change things too.
But I'm not sure which way that cuts.
It
Couldn't
seems
that-
to cut that he's keeping her there. He's gone out drinking. He says in 2 weeks I'm going to be in the news. And he's got a camera in there.
If
he's not behaving like your regular criminal here. He's done some strange things already.
Sure, but a lot of criminals, in both of our experience, we've seen examples in civil and criminal cases of people acting not in their best interest or not in the most rational of fashions. But I think that the fact that he said at the restaurant several times that his girlfriend was in his apartment makes it possibly even more likely, as I said, he wants to keep the body there. So he wants to keep, to hold on to maintain the memory, he even testified at trial that he wanted to keep her there
Well,
forever.
that's a little-
at
that's
first.
probably a
And so
little
he's
strong.
more likely to use a camera to memorialize it.
Well, that's a little strong. He's gone drinking right after he's killed her, right?
No, he has not gone drinking. He has he's gone to this restaurant where he orders one tall beer, a Taj Mahal, which he nurses over 7 hours.
I'm keeping the drinking incident separate first, the
Okay.
amount of drinking separate. But what he's done is he's left the apartment after killing her.
Yes.
So he hasn't, we don't know he's memorializing this as opposed to running away from it at this point. But he has, but anyway, I'm just trying to think logically. We've seized the camera, it's totally permissible. It's a domestic relations crime. And it just seems like the judge gets it right, that there's likely to, I don't know what the standard is. Once you've properly collected it, do we need probable cause to believe that the camera itself is going to reveal?
Yes, there has
Okay,
to be
so that
some
point-
particularized, I think in that
The
sense, there's
next
got to be
step-
a reason to believe, other than general, that there will be particularized evidence.
That's a distinct search of the camera
Yes,
in a
yes, it
separate
is.
search warrant. I
Yes,
get you.
yes, it
Okay.
is. And here, I think you have the additional factor of the knowledge by the magistrate and by the officer that there was an outstanding domestic between them. So they had a history of violence. So as has been said, the camera might show pictures of her in the days or weeks or months leading up to them that'll be relevant to show what might have happened on that day. That was within the officer's knowledge, within the magistrate's knowledge when he allowed it. Of course, we defer, in large part to these determinations to the magistrate.
Well, and we're also limited to the four corners of the
Four corners,
affidavit.
exactly, right. So the fact that the officers knew what was on the camera before they prepared the second affidavit is not relevant when determining if that second affidavit provided probable cause for them to
Tell me
believe.
I agree with that, but could you tell me what the particularized evidence was? The nexus between the crime and the camera?
Yeah, the fact that it was a domestic homicide, that they'd had a relationship, that they'd had a violent relationship, and that there were charges outstanding against the victim. And also, what's not been mentioned, that the defendant consented to the search of his apartment, which is also a little odd. So he might have taken.
The body in the corner, yeah.
Yeah, so that
Yeah.
shows that he might be the sort of person who would take a picture of a dead body, even though it incriminates.
But that, again,
him.
that's not
and
in the
keep it.
warrant, in the four corners. We're looking at just what's in the four corners of the affidavit?
Oh, no, it says that he consented to the search.
Right.
That's
okay.
in the affidavit.
Okay, so his
that's
consent is
yeah,
in there.
Yes, that is in there. And his statement about the 15 days and the things that I mentioned earlier, plus you can take into account to some degree the experience of the officers, which as I said, and I'm glad I was a math major in college, 102 years of experience, these 5 state police officers. And it appeared that Judge Feely credited them, and the magistrate was certainly able to. That is the evidence that we have, Justice Link, that provides the particularized, that provides the evidence that there might be, I'm sorry, I'm going to start this sentence over again. That provides the particularized basis for a belief that there will be something on the camera that's relevant to this offense. And it's a limited amount of facts, and either you think it's enough or you don't. That is the question for this court to decide.
Can we shift you to the convention for
Sure.
a second? So, please, the government drops the ball and doesn't contact the consulate, right? They should have contacted the consulate, particularly when the the defendant expressly requests it, right?
No. The right under Article 36 is for notice at the time of arrest and detention. That is when it applies. There's nothing that says that they have an ongoing obligation. Yes, they dropped the ball, but when they dropped the ball was at the time of his arrest and detention. And he has to show that he was prejudiced by that, and he clearly cannot. And the fact that he repeatedly, for years, contacted.
But okay, so they should have contacted at the time of the arrest and detention.
Right, and there's no evidence that they did.
They don't do that, and then he has trouble getting through to them.
Well,
Meaning, it doesn't, we don't even know whether, do we know whether he actually made contact with them?
yes, he said he repeatedly contacted them.
Well-
Repeatedly. He doesn't say the method, he doesn't say,
I've
he never
repeated-
says, I sent a letter to this address, I contacted this, I called.
I know,
he never
but
says
I've
that.
repeatedly tried to get my generator fixed. No one answers the phone. So do we know he actually spoke to somebody?
No, all we know is that he repeatedly tried to contact, what that means. And I think it's a fair reference, the way he talked about it so often, that he sent them a letter or that he called them and that they ignored him. I disagree with my sister's notion that they're more likely to respond to a notification from the prosecutor than from an Indian national who's being held under these charges. I think, as I say, the best evidence of what the consulate would have done if they had been notified at the time of arrest and detention is what they actually did do the many, many times the defendant contacted him, which was nothing.
Problem is, we've got this ex post facto letter that Attorney Greenberg's got them to write.
Sure.
Which says we would have helped him had we known, right?
We would have helped him. No, it never says
It's a,
we would have appointed counsel and paid for it had we been notified at the time of his arrest and detention. It merely says very cleverly, very trickily, if that's a word, that if we had known on August 7th, 2012, that he was having problems with getting information from his attorney, and she kept continuing the case, then we would have stepped in there and hired a lawyer, and that would not have changed the trial date less than a month later. Which I don't think I don't think that adds much at all to the defendant's case. And certainly, even if there's a violation of the Vienna Convention, which I don't think there's any. I'm sorry. There was by the initial failure. Nothing after that constitutes a violation of anything. He's got to tie it to the right to counsel of choice, because otherwise he's got to show a substantial risk, and he hasn't even tried, and he says, I don't have to.
Oh,
And he says that there was none, and there's no way to link.
their argument is essentially, had you helped him get through, they would have stepped in when the attorney wants to get out of the case. That's their argument. So I'm not sure it holds together, but that's their argument.
Yes, that is their argument. But as Judge Feely held extensively, I would not have continued the trial, and there was no individual attorney standing in court in front of me. The idea that in the abstract that they would go out and find somebody, that would take time, that would affect the prep. There's no reason at all to believe that the Indian Embassy would have had a person available less than a month later on September 4, ready to go to trial.
Except for what they said. I mean, they make some kind of representation that they would have done something.
Right, but that's not the same thing as saying we would have had an attorney ready and prepped by September 4th. It says we would have done something, which I don't think is enough. And as I said, he'd have to show prejudice, and he hasn't. And there's no violation of the right to counsel has been shown.
Well, there is a violation of the convention.
Yes.
Okay, so what is and I mean, if the police don't do what they're supposed to do at the time of detention, aren't they still supposed to do it later, even if they don't do it timely? Are you saying that
No.
basically the window, if they don't notify them upon the time of arrest, then
Right, the violation has
they never
occurred.
should?
Well, should is a different word. I don't think they're legally, it's not a further violation. It's not a continuing.
Why isn't it a continuing violation? If it hasn't happened when it was supposed to, you're saying that, oh, well, it's over.
Because that's the only right he has is notification at that time. And as I said, the consulate was notified by him.
No, he tried to get in touch with the
Well,
consulate.
Well, but I think that it is fair to read that as he contacted them and he notified them and they did not act. I don't think you can just say that his efforts, he called a random phone number, nothing. I mean, he obviously took some steps. But even if there was
He's in jail throughout this time, or is he bailed out?
I believe he's in jail.
So do we have records of him calling from the jail?
We have no evidence whatsoever as to the method, the timing. He just says, I frequently tried to contact, and literally there's nothing else, Your Honor. But he still has to show that the result of the trial, suppose there was an obligation that continued throughout.
Let me ask that. I mean, what is the standard? Let's assume we find that there was a violation.
Yes.
What is the standard?
Getro is very clear that he has to show a substantial risk of substantial likelihood of a miscarriage of justice to show that it is likely that the verdict would have been different. That's right in Getro. There's a line in there, and I cite it in my brief. I might not just have said it exactly, but he's got to show that it would have, or a likelihood that it would have had some effect on the verdict if they had appointed him counsel. And he says explicitly here before you, as he said in front of Judge Feely, I don't have to do that. I'm not going to do that. And I can't do that because he cannot show that the outcome might or would have been different had he hired an attorney, or had the embassy jumped in less than a month before and hired an attorney. It's right in Gautreaux's the answer to your question, Your Honor.
Okay. Thank you.
Thank you very much.